in that case.
That's correct. It was from the First Circuit, and it does not apply, like I said, to concealed recordings, but as to this court and as to the clearly established standard in the Harlow versus Fitzgerald test, this court has always looked to the clearly established as a national standard, such that circuits that the controlling case law to clearly establish need not arise from the circuit in which the case giving rise to the cause of action took place. And the case that really gives the clearest rundown of the types of sources this court is willing to look to is Wilson versus Lane. In that case, the events took place in Rockville, Maryland, which is the Fourth Circuit, and this court looked to decisions from Wisconsin and a Wisconsin state case and district court cases from Ohio and California. And in addition, another thing I want to point out importantly about the Wilson case that I think it brings out about the reasonableness definition in a 1983 context about the way in which we view First Amendment protections and how First Amendment protections are really built into our very definition of the reasonable officer standard, even at a qualified immunity level. Of course, Wilson versus Lane is the case in which Officer Lane brought along a Washington Post reporter to execute a warrant within a home during an arrest. And writing for the court, Justice Rehnquist wrote, it was not unreasonable for the police officer in that case to have believed that bringing a reporter along was lawful. Because accurate media coverage of police activities serves such an important public purpose that the officer was considered reasonable in that case. I think here we have the opposite, where we have highly unreasonable assumptions by an officer who should have looked at my client and seen protected First Amendment speech and instead arrested him. And for these reasons, we ask that you affirm the 14th Circuit and remand for trial. Thank you.
Thank you. Thank you. Rebuttal?
Thank you, Your Honor. We would like to address the respondent's claim that this was content-based enforcement of this law and that should suffice for their 1983 claim. There are several points that need to be addressed on this, first of which is that sounds like a discriminatory enforcement claim, which is a claim brought under the 14th Amendment Equal Protection Clause, not the First Amendment. And in fact, the courts that have addressed claims similar, where parties alleged that there was unequal enforcement, even in reaction to First Amendment expressions, have found that that must be brought as a cause of action under the 14th Amendment, most notably the D.C. Circuit en banc that said you can't do that under the First Amendment. And again, the respondent has not alleged a 14th Amendment claim here.
Are the claims any different in substance?
Again, Your Honor, it gets into whether or not the respondent was being treated equally. And so even though it implicates the First Amendment, it is ultimately an equal protection claim. And then even if this court were to entertain that, which this court never has entertained a similar claim under the First Amendment, there must be a pattern alleged under discriminatory enforcement as held by this court in Thomas versus Chicago Park District. None of this has been alleged. The 14th Circuit didn't rely on this for discriminatory enforcement. The second option under which such a claim might be brought is some sort of retaliatory arrest, but again, that hasn't been claimed and that wasn't relied upon by the 14th Circuit. And furthermore, that was foreclosed by this court in Reichel versus Howards, which found that retaliatory arrest could not overcome qualified immunity when there was probable cause for the underlying arrest. And in addition, the concurrence in that case held that when officers are in a protective role, comments made or expressions made to the subject of that protection have a certain importance that we shouldn't parse the subjective motivations in reacting to those when they break the law. And in this case, that conduct does break the law. And then our last point, if I may conclude, Your Honor, is that this is an objective, reasonable test, not a subjective test. And as Your Honor pointed out, the district judge to hear this case agreed with Officer Lochte, and that may be the best determination of what is objectively reasonable in this jurisdiction at the time. Thank you very
Right,
much.
thank you very much.
All rise.
Well, we're gonna step off or let the dean talk? Yes. So,
Normally, we would stand up and leave you all, but we've chosen to stick around, if that's okay.
and I think we have some words from our dean.
Well, first, I want you to join me in congratulating our oral advocates today. And many thanks to our wonderful panel. I asked them not to be too hot or too cold. I think they're a little on the hot side. But we're so grateful, and I know that our Chief Justice wants to, and the other panelists want to say a few words, so I'll turn it back over to you.
All right, thank you so much. Mary Kay, you wanna go first?
I just want to congratulate you on the great job that you did. I started trying to make notes so I could tell something to each of you specifically, and I found that I was writing the same thing for all four of you. You're all very poised, you're all very respectful, you're very articulate, you're very organized. You stood up to some hot questions, as the dean would say, and still were able to deliver the points on behalf of your clients. You should be very proud of the job you've done. You've far exceeded many of the attorneys that are far more experienced and then that I have seen over time. So I congratulate you all on a great job.
Well, let me echo her statements. I think you all did a very fine job, and she's absolutely right that you're already better than the average person who appears in our appellate courts today. So I applaud you, and I appreciate your indulgence in our hot questions.
I can only second what my colleague said. You were all really, really, really good. And one of the things that you did for all of us, I think, is you tried to answer our questions as best as you could. Sometimes the questions were fair, sometimes they were unfair, sometimes they were crazy, sometimes they were sort of normal. But good appellate attorneys, I think, try to answer a judge's question as best as possible, even if they think it's off the wall. Because most of the time, judges are trying to figure out pressure points or whether or not their instincts about a case is right or wrong and whether they can be persuaded otherwise. And lawyers who don't try to engage in that dialogue, I think, are going down the wrong road. And you all did that very well. And then, very seamlessly then worked back into the argument you wanted to present, even though you were getting dragged off target. So you were very wonderful, and it was a pleasure for all us to be here and participate. Thank you.
We are going to have take some pictures afterwards. Everybody is invited over to the reception, which is in McKenna Hall atrium. But when we take the pictures, I know that the advocates will want to have a chance to get some individualized feedback from the judges, and the judges are happy to do that. So the rest of you, go off to the reception, and I'm sure everybody will be over there very soon. Is that correct?